Good evening. Depends on where you live. It'll be still good afternoon. I'm attorney Jae Francis. I'm a U.S. immigration lawyer based in Chicago, but serving all 50 states. Today, September 5th, this is 5 p.m. Central Time. We're going to talk about, two important immigration options that you have. One is, keeping family together parole in place. Another one is 601A waiver. What I'm going to do is that I'm going to start with what's going on with keeping families together parole case first, and then I'm going to talk about 601A waiver, and then I'm going to compare two different options that you have. It's a very challenging time because, because of this litigation, we have updates almost every other day. So let's get started. Now, September 3rd, Tuesday, Department of Homeland Security filed a motion with a court in Texas asking two actions. One is to, number one, right, end the stay. As you know, that the judge ruled this administrative stay until September 9, and the DHS on September 3rd asked the court to lift it up so that USCIS not only, accepting and processing cases, would be able to approve pending parole cases. As you know, the USCIS not allowed to approve any pending cases after the court issue this temporary restriction order. It has many different names: TRO, injunction, or admin stay. So the spirit is that the USCIS not allowed to approve any pending cases. So then DHS filed this motion. Number one, lifting this stay so the USCIS will be able to approve cases. And number two, DHS asked the court not to extend stay 14 more days. So they filed. It was 60 pages with a good arguments and good citation of the cases. But unfortunately, the judge next day, super fast, September 4th, ruled against DHS. So judge refused to lift the stay, cited many different reasons. He contemplated that the state of Texas and other plaintiff, DHS, had a good argument both sides. But when there is a serious consideration to be reviewed, then the judge went with state of Texas and other plaintiffs, saying that it's a so serious claim that it warrants status quo. It means that because state of Texas claim and others that if the USCIS is allowed to grant paroles, then there will be harm, reparable harm done to states. So then judge said that considering this possibility, judge decided not to lift the stay. So that's number one. And number two, not only just continuing the stay, but extending into September 23rd. So adding 14 more days. So as of today, temporary restriction order or admin stay will be in effect until September 23rd. Repeating one more time, until then, USCIS allowed to accept and process cases, but not allowed to approve any pending cases. On top of that, the same order the judge made on September 4th, then he put a hearing schedule for September 18th, expedited hearing schedule. And then they're going to decide whether the court will issue preliminary injunction. So what's the difference between temporary injunction and the preliminary? Now, temporary says, obvious, it's a temporary, right? And for now, it's until September 23rd. If the court issue preliminary injunction on September 18 or thereafter, then this injunction or stay will be in effect during the pendency of the litigation. So until the court rule on the merits of the case, devastating. It means that until that, if this ever happened, then until the court rule in government's favor, USCIS not able to approve cases. So once again, only allowed to accept and process parole cases. So September 18 is very critical date for many of you. Having said that, this Keeping Families Together parole program was introduced as a viable, faster, potentially better alternative to 601A waiver cases. For those of you who had a pending or approved 601A cases, you got text or email notification from the USCIS right before USCIS started taking cases on August 19th, right? Said that we have your pending approved cases, and then would you like to, explore this new option? Many of you got this US invitation. So the spirit of this Keeping Families Together parole program was to give better options than waiver cases. Why? Because as you know, many of you are going through or went through this process. Number one, very expensive, right? Most of you work with immigration attorneys. You need immigration attorney because it's a challenging, right? You need to show extreme hardship to your US citizen or permanent resident spouse. We're not talking about we love each other. My spouse will suffer emotionally without me. I mean, we're talking about highest levels of hardship to be done to US citizen or permanent resident spouse. Extreme hardship. So it's not easy. There's a lot of moving parts to make really good waiver case, 601A waiver. So expensive. And number two, very lengthy process, right? Most of you went through I-130 or 601A waiver, or for if you're from Mexico, many of you are from Mexico, you're still waiting for interview to be scheduled in Juarez. Everything takes quite some time. So before we wrap up today's session, I'm going to talk about a viable way to expedite your 601A waiver case. Why is it important? Because we don't know whether USCIS will be able to approve your case. You have a pending cases, right? You're thinking about submitting your cases, but we don't know whether USCIS will be able to approve your case. That's the key point. So let's circle back in the previous conversation about your options, right? So number one, right? If your 131F parole request has been approved, right? If the government approves yours, then you don't need 601A waiver. You don't need consular process. You do marriage green card case. You do adjustment of the status. You do it inside the United States. You don't leave the United States and go back to your home or any other country. That was the spirit, right? And once USCIS approves your 131F parole request, that's permanent. Whether court say that the program is unlawful, or if Trump's come back next January say that, well, I don't like this, I'm gonna terminate it, it does not really matter. Once the government approves your 131F parole request, put it in your pocket because it's a permanent. No one will take away your case unless you and your spouse going separate ways, right? Because remember that this second stage of this option marriage green card case, you need U.S. citizen spouse, right? U.S. citizen spouse. And if you're going separate ways or being divorced, then you don't have a case. So that's like a number one rule, right? Once you have a approved 131F parole request, it's yours for good, right? And you have 3 years to start your marriage green card case. So that's in the book. Now, what if your case is pending, or you're still thinking about, submitting your keeping family together's 131F parole request now, knowing that maybe USCIS may not be able to approve your case? Many of you are thinking or still waiting. Hopefully you're watching this video, live show. So then it's really confusing and important at the same time to know what you're supposed to do with your pending I-130 or approved I-130, pending 131, 601A, or approved 601A. So I'm gonna switch my topic into 601A waiver because it's important. And then many of you who's watching this video already went through this process. So I'm gonna keep it a little bit short. But for those of you who thought about starting 601A, but for many different reasons you didn't do it, you hope that this keeping families together parole is for you, good option, but you're discouraged because of what's happening with the court action, then maybe you will think about doing 601A waiver now. Let me drink some water. Okay. So 601A waiver basically has 3 stages to make it simple. You start with USCIS I-130 petition. I-130 petition takes quite some time. It's getting better, but now it takes about 12 months to up to 18 months. So that's how long it'll take. I-130. You start with I-130 with the USCIS. Now, then when I-130 is approved, then you pay NBC filing fee of $445. And then when you pay, then you start waiver process. The waiver, 601A waiver, you need to show extreme hardship to U.S. citizen or permanent resident spouse. Now, this waiver, as I explained a little bit earlier, you need to show extreme hardship to your U.S. citizen or permanent resident spouse, not about you as a foreign national who enter without the visa. So that's what you need to show. And there's many ways to prove extreme hardship. I'm gonna make new video about this, how to process your waiver case. But you can go with financial hardship, and then emotional hardship, medical hardship, or relocation hardship. It means that if I'm not allowed to stay in the United States, then my spouse and whole family will go to my home country and suffer the by now. And then some of you who are new to this process, to have a successful 601A waiver case, you need a qualifying relatives. And then in this context of the video, we're talking about U.S. citizen or permanent resident spouse. So that's 601A waiver. The problem is that it takes at least 2.5 years, and then even up to 3.5 years. So 2.5 years and 3.5 years. Now, and then when it's approved by the USCIS, right, you're still in the United States, then you complete National Visa Center process /CX, right? You submit DS-260 application, A64 form and supporting documents, and all the civil documents to CX. And when NBC approves your case, then you wait for interview. For those of you who are from Mexico, you know that there's an extra wait time built into this process. So one more time, this waiver process from the beginning to the end takes about 4 to 5 years. It may take longer. So let's talk about how to expedite your 601A waiver case. And then I'm going to talk about when would be a good time to do it. Um, you will file this writ of mandamus lawsuit after waiting for 1 year. Some of you wait 2 years. So I'm going to walk you through. So when the government is slow at reviewing your case, then you can file a lawsuit in local federal district. It's called writ of mandamus. Just people call it mandamus lawsuit against the government. In your case, USCIS. And then when you file this lawsuit and serve the summons with the defendants, then they have about 60 days to respond to the complaint. And in most cases under Biden, USCIS will settle. When they settle, following will happen. Number one, instead of waiting up to 3.5 years, USCIS will approve your 601A waiver. So approval. Or number two, they may issue the request for evidence. They say that we're not convinced, you need to show more extreme hardship, or you didn't submit your US citizen spouse, US citizenship document, all that. So that's a possibility. So usually two outcomes. Now, and then the benefits of filing mandamus lawsuit is to compel the USCIS to take an action instead of sitting on your case and doing nothing up to 3 years and more. And then, like I said, we have mandamus lawsuit against the USCIS in the context of long pending waiver cases. We have like waiting about 1.5 years and 2 years, and we file mandamus lawsuit and then end up in approval. So that's how you expedite your 601A waiver case. So a lot to think about it. And then also I'm gonna finish up this live stream with what to do with I-130, right? So many of you are confused about sort of figuring out two options that you have. One is you have a keeping families together parole case, right? We're talking about pending cases where you're thinking about submitting new one. And then, for those of you who have a pending I-130 or approved I-130, as I explained earlier, that unless your 131F parole request is approved by the USCIS, you shouldn't do anything about I-130 or 601A waiver, because unless USCIS approve it, then it doesn't do any good for you. So unless the USCIS approves your 131F parole request, you should not withdraw I-130. You should not withdraw 601A waiver. And then there's a little bit of detail what to be done, I-130 and all that. But let's sort of confine our conversation into I-130 only. So for those of you who have either approved I-130 or pending I-130, but haven't started 601A waiver process yet. So I'm just talking about those of you who only have I-130 pending or approved at this point. And then you enter without admission or parole, obviously, right? So as I mentioned, you should continue processing and waiting for parole case. And at the same time, if your I-130 is pending, you need to wait for it. Now, when your I-130 is approved and then your parole case is approved at the same time, then you can sort of recycle approved I-130 and attach into your 485 application. So then this part is for you, those of you whose parole request has been already approved, right? So then when your parole request is approved, then you're able to submit your 485 application to adjust your status to permanent residency. And then also you can add your pending or approved I-130 into your marriage green card case. And then I think that it's cheaper to apply for 765 employment authorization document. You call it work permit with this marriage green card case, then through the parole case, right, you pay $260. If you go with 485, filing concurrently with 765. So you submit 765, and then I don't recommend that you do 131 travel permit application because it costs more money. 630, and then it takes quite some time. So marriage green card cases go fast, relatively fast, still 6 months or 4 to 6 months. I would say 6 months now, starting from August, 6 months. Previously, between April and July of this year, marriage green card cases went really fast, less than 3 months in most cases. But now it just become a little bit normalized. Like 6 months is a typical for marriage green card case. So circling back, 45, recycling I-130, submit 765, and then you need to submit 864, affidavit of support, right? And then also you need to submit 693, immigration medical exam and supporting documents. So it's a challenging time. And then I talked about, the current status of keeping families together, parole in place. And then also I talked about 601A waiver and how to expedite. Now, I'll see you next Thursday, 5 p.m. Until then, be safe and then be happy. Thank you so much.